All right, well, welcome everybody to the 6th annual Bench Bar CLE. Really appreciate you coming out on a Friday afternoon to hear from a panel of, we'll have 6 judges. Judge DeLuca is on her way. There were some questions that were submitted via email. Anybody who still wants to ask some questions, you can submit those via email if you want to stay anonymous. There will be a few moments for asking questions, but we have some good ones on email that we'll be asking. This will be on demand for anybody who's not here that you want to let know that this happened and that they can watch it themselves. Everybody got the packet of information that has all the notes from the last 5 years, which I think is a pretty cool little treasure trove there. You'll be getting another email within the next 10 to 15 minutes or so from me. It's going to be what I needed to have in there from Justice Castle. What he's talking about here, he did a one-pager and I forgot to include it, so it'll be coming in your email. And make sure to sign in for CLE credit. Iowa CLE credit is still pending. They're a little bit slow in looking at their applications. It will be accepted for credit, and I will send out that note to everybody who needs Iowa CLE credit. Any questions before we get started on housekeeping issues? We will take a break, a quick break at the 1 hour mark. There are restrooms inside this room facility over to the right, along with a water fountain. All right, I'll turn it over to Justice Castle.
Thank you, Dave. When Dave asked me to do this, I sat down and put together a top 10 list for appellate practice. And I have to tell you, when you'll see in the email, they're numbered, but the numbers really don't have the significance of the typical top 10, number 10, number 9, up to the best. They're all important, and a number of them go together. And I'm not even sure that today's top 10 would be the same as the top 10 that I put together when I did this a couple of weeks ago, because it varies as things change around the court. We notice things that are percolating, and they penetrate into the consciousness of those who are working there. I asked our new clerk of the Supreme Court and Court of Appeals, Josh Sachere, and I'm still learning how to spell his last name, so if you haven't mastered it yet, don't feel bad about that. There's a bunch of us that haven't. What he would say was the most important thing to convey to you, and it's number 2 on my list, which is follow the briefing rules. So I already had that on the list. As I go through these, I'm probably violating one of the rules, which was rule number 5 on the list, which is wisely use your oral argument time, because I am going to try and touch on all 10 of the items in the list and still leave 10 minutes for questions and answers before. So I'm going to hit these and bounce away, or dance away, as my colleague Justice Stacy would say. The first one on the list is make the record below. And you will find almost all of these are in the form of phrases that begin with active verbs, and that is not a coincidence or an accident. And one of the things, as you are writing for the appellate courts, and most of our communication is still written. And yes, there are oral arguments in the Supreme Court, and there are some oral arguments in the Court of Appeals, but most of our communications with you are written, and it's important that you master the writing skills, and I have a bunch of my points that deal with that. But make the record below is one that I drew from the movie Chariots of Fire, which coincidentally was based on an athletic principle, supposedly, that you can't put in what God left out. Those of you who saw the movie will remember that quotation. And likewise, in the appellate court, you can't put in what you didn't put in or nobody put in the court below. So making the record below is a critically important thing. And in terms of appellate skills, going along with that, I would say knowing the record and knowing it thoroughly is one of the best advantages that an appellate advocate has, because certainly the appellate judges will not know the record as well as you do, assuming that you are thoroughly conversant with it. Follow the briefing rules, Josh says. I think the ones that I'm going to touch on for just a moment, you will look in what we old-timers would call Rule 9. It's 2-109E, I think. No, it must be C. And the subparts have changed. But what is important is there is a description of what each section of the brief should look like and what its content should be. We do not set forth in the rules or in any commentary that's presently associated with the rules the reasoning behind it, but if you sit down and look at that and think about it, the reasoning is pretty obvious. And if I were to point out what I would say the single biggest thing that appellate advocates fail to live up to is to provide us what we ask for in the order we ask for it and at the time we ask for it, and not to put it all in the front load. In other words, I'll see the whole history of the case in the statement of jurisdiction, and then it's repeated in the statement of the case, shows largely up again in the statement of facts, and by the time we get to argument, we're maybe the fourth iteration of the same material. You need to understand we read a lot of pages in the course of a month. I figure around 10,000 pages a month is what I read. And someone who writes sparingly, and I'll get to that as one of the other points, is worth his or her weight in gold. Be sure to both assign and argue error. Like we still see briefs where there will be an assignment that's not argued or an argument that's not assigned. And that rule has been around, well, at least all of the 45 years that I've been practicing law, but we still see that problem arise with some regularity. Wisely using your oral argument time. All of the judges on the Court of Appeals and the Supreme Court are familiar with the briefs. They are familiar with the parts of the record that at least someone has called to their attention. And so spending a lot of time on the facts is not particularly a good idea, but being ready to have the killer answer for the facts tied to the record could be a very wise use of your oral argument time. I have 5 of the bullet points, if you will, that are related to one another, and I'll just reel them off and then talk about them as a group. Structure is important. How you structure your brief, even beyond the bare bones that are rules set forth, there's a lot of flexibility, and it's important that you think about how you structure your brief. Lead with your best argument. I think it's a strategic error to have, I know some people like to approach things in chronological order, but rarely is chronological order the best organization for what you're really wanting to complain about. And particularly in the 10 minutes that most arguments have, you rarely have an opportunity to actually talk much about more than 1 or 2 subjects. So leading with your best argument is important. Develop your appellate theme. What I'm getting at there is, I think all of the trial lawyers that practice actively that I know of well understand that when they approach a jury trial, they have a theme that they're using to propound what they are trying to convince the jury to do. And everything they do is tied to that theme in one way or another. I think I would suggest to you, you should have an appellate theme. Now, the appellate theme is going to a different audience. It's going to a group of judges who the arguments that you make to a jury are not generally going to play very well with the appellate bench. But I think having that appellate theme and then organizing your brief around the appellate theme, if there's a big error and there are a lot of little errors that go with it, you start with the big error and then you build on that with the little errors. Simplify, simplify, simplify. One of the most important things that an appellate lawyer can do is to organize the material in a way that leads the appellate judge to a single conclusion. And certainly when I was at the Court of Appeals, the opinions that frequently went out that were in-house opinions, in other words, the ones that neither were published nor went on the internet, tended to be longer opinions. And there's an old saying, and at least that magical source of all things true called the internet tells me that the saying, if I had more time, I could make it shorter, goes back at least to the 17th century. So I'm not talking about anything that's particularly new, but simplifying and organizing is the most important thing that the appellate lawyer can do. And the last part of this is craft your argument like a fair decision. This is your chance to write how you think the case should be decided, and if it's just all one-sided, and if you have focused on arguments that are weak, you will take away the focus from the arguments that are stronger. So give or concede what needs to be conceded that you're going to lose anyway, but focus on the things that you really need to. The 10th one, although not in the order on the list, is treat citations like hand grenades. And that's just a fancy way of saying if you're not careful, citations can blow up on you. The goal, of course, when you have a citation is to have it blow up on the other side, but be careful that it doesn't go off prematurely or go off in your hands for a principle that you weren't citing it for, but that your opponent is clever enough to see. So I think maybe I went over my 10-minute budget, but I think we still have about 8 minutes to stay on schedule for questions, and I'll be happy to respond.
Justice, one question submitted was when addressing the entirety of the bench, is there any term other than may it please the court or your honors that's appropriate? Have we relaxed on that at all? And if so, what's
well, the one that's pretty clear that you shouldn't use is you guys. Our current Chief Justice, soon to be former Chief Justice, has tried to make a passion of curing the bar of doing that with not entirely total success, I might add. And whenever one of us hears someone say, you guys, we all sort of look at the chief and see if he's going to unload on the poor lawyer who did that. Although some of the lawyers will do it and then realize what they've done and fix it, which, generally we let that slide. It is so ubiquitous. The lack of formality in modern day society is just so different than it was when I started practicing. And I look at Judge Caporelli, I'm just amazed. Here he is. He looks the same as he did when he left the Supreme Court, although those more than a few years ago. But I'm sure he would agree with me that the formality in society as a whole is completely different, and you should strive when you're appearing in front of one of the appellate courts to maintain that level of formality that maybe doesn't exist in almost any other place.
If I can ask a follow-up question, this is from last year, but I think it was a good question to ask again of a different person from the appellate court. Is there any rhyme or reason to what is pulled from the Court of Appeals? And there are certain things that are, but then there are certain things that aren't. Can you give us a little bit of sense of when something that you think is going to go in front of the Court of Appeals is actually just pulled by the Supreme Court?
Well, I'm not sure everyone realizes, but for all the cases where there is no petition to bypass or no notice of constitutional question, which would call those cases to our attention through a slightly different path, all of the rest of the cases that are docketed in the Court of Appeals are reviewed by the Supreme Court for possible movement. Now, whether they get moved or not, there's a whole bunch of things that go into that, and it can be just as simple as there's a huge record and there are a lot of issues, and the Court of Appeals, I know, having served there, does really well on moving cases very quickly through the appellate process. When they get what my colleagues at the Court of Appeals would have called a coffin case with a huge record, that slows them down in a way that hurts their efficiency. And because we have more personnel, I think, probably will take some of those just for that. Now, the ones that we think maybe have a novel issue, we'll certainly take those. And then we'll just pull some out just because we need cases to fill out our docket. And they frequently are ones that we had already voted not to move. And then the chief will get together with the clerk. And we do when we do not move, when one judge has voted on the first round to move a case, it will go to consultation. And if we do not move it, we'll say do not move high or do not move low. And that's generally the do not move high is supposed to be the first ones that would get moved if we have to pull them in. And I think the chief has sort of exercised the prerogative and nobody's questioned him about that.
Any other questions?
Don't be bashful.
Once, twice. Andy, you have a question?
All right. What the hell?
He always has a question.
I attend it's the Federal Public Defenders Seminar every year, and there's a gentleman out of the Eastern District of Washington that's come and spoken on the style of brief writing. And he's an out-of-the-box kind of guy. Throw away everything that I'm pretty sure all of us were taught in law school. Follow the format, comes now, heretofore, all.
Yeah.
Ignore that, is his message. How do those briefs, as long as they conform with the rules, hit your butt?
I am a believer, if it's the fellow, I think I may have seen this fellow speak.
He's an happy dresser.
That would fit, but this would have been 12 or over 12 years ago, because I was still on the Court of Appeals when I saw the person speak about it. There are others that have talked about it, but the key to this is nobody, and I'm talking none of the judges on the Supreme Court or the Court of Appeals, read briefs on paper anymore. We're all reading them on devices, and there is a field of psychology that's devoted to how people read and the way their eyes move as they're reading things on screens. And so I would encourage all of you to look at that science, adopt what seems to make sense to you, and organize your briefs, because we no longer have page limits. We have word limits. We have to have some kind of a limit, but We no longer have page limits, so you're not tied to what I have called over the years the tyranny of squeezing things into a page. You can organize the pages so that they flow, they make sense, and they emphasize by using bold or italics. Bold and italics, maybe not as good. Not underline, because we don't want that to be confused with the hyperlinks. And all caps, I really, that's like shouting at judges. So I would suggest that that's not a good idea, even in assignments of error. And I used to write them all that way because that's the way they did it when I started practicing. The assignments of error were always in all caps. I don't think you should do that anymore. But follow up on that line of study, and I think you all, when I say you, I don't mean just Andy, but everyone, to understand what the science is behind it.
Great. All right. I think we'll
Okay.
let you go, Justice Castle. I know you have somewhere else to be, but thank you so much for.
Thank you very much. I've enjoyed being here.
We're going to move up Justice Caparelli in this seat.
No. He'd probably do a better job than I did.
Have a good weekend.
Thank you.
Well, next we have Judge Thompson from Sarpy County District Court. I'm very excited to have him here today. We've heard from Judge Martinez, I think, 3 or 4 times, and we heard from Judge Cox, but we're really excited to hear from you.
We got a senior judge now, so I inherited that about a year onto the job.
So if you could let us know what we should be doing and not doing in your court.
All right. Well, you guys, sorry, I had to pick up from the last one. I know. I would say the first thing, and it's been emphasized in the past couple of years, but look at the local rules. And I'm kind of speaking from the non-Douglas County aspect of it. And I don't know if anyone understands how you come up with the rules. In order for us to have a rule, and a rule that applies to our jurisdiction, we have to have it approved by the Supreme Court. So those are the local rules. When you go to the Supreme Court's website, is the rules that we have to follow. There is internal rules we have with managing and docketing cases. Those are internal rules. And sometimes our internal rules can conflict with other jurisdictions. And so how far is the assignment of cases and everything else? For example, Judge Martinez does the majority of the specialty courts. And in order to loosen that caseload, Judge Smith takes on a portion of her civil non-domestic cases. And Judge Martinez takes a little portion of his domestic cases. So if you find yourself filing civil non-domestic cases and keep pulling Smith, it's because there is a shift there. But the local rules, a lot of the answers are in there. I'm going to talk about it in kind of 3 aspects. And I'm going to start with the domestic law first, because that is 65% of our cases. The local rules talk about temporary hearings, what needs to be prepared, everything else. Now, you are going to get the nuances with all the judges. I mean, we all have our own quirks and matters. But for the most part, the filing of the case gets assigned to one of 3 judges. Judge Smith carries a 25% caseload in Sarpy. And inside those local rules are general principles that you have to do. But each of the judges, once we see that service has been made, we have a pretrial order that goes in effect. Now, a few years ago, we decided we're going to do pretrial hearings on domestic matters. And here's a little secret. The only reason we wanted to do that is to bring 2 attorneys together to talk about the case. There's no simple matter. So as opposed to Douglas, we don't have this long progression order. We generally just have, okay, we're going to meet in a pretrial. And the mediation requirement is probably the biggest thing we're looking for. Do we have a reason on the record to waive that, say there's no children? Or is there a reason that we need to double down on it and we have 2 parents that just cannot communicate with each other, and the attorneys are probably upset that they cannot, even convey a message to their client without the situation exploding? we're pretty stringent on that mediation requirement. So that's what we're looking at when we're a little bit into the case. But you wouldn't necessarily know that if you don't look at those two things. One, look at the local rules and everything else. Insofar as the criminal docket, if we're going to do a comparison, we're probably closest to Douglas County in the way that we handle it. We don't do in-court arraignments, but every month we get an attorney that says, well, I was showed up at the hearing for the arraignment. Well, look at the local rules. We don't do those. Those are just so we don't lose track of a case. And we want to make sure that your client's not in the wind or something else like that. That's the initial start of it. On the civil non-domestic caseload, what you'll see is once we kind of get through the battery of the initial motions on the pleadings, you're going to see a mediation order in most, if not all, the cases. Our view is that we have to put priority on the criminal cases because they have a 6-month right to speedy trial. The domestic cases back up to that, and then the civil non-domestic cases back up to that. We wish we had the ability to bring in cases on an equal basis, but we have to prioritize that. So when you see a mediation requirement on a civil non-domestic cases, we're just trying to get your clients some action or maybe some form of relief besides waiting a year and a half to come in on those matters. Breaking it back down again with the local rules and with the different types of cases, there is a page limit on domestic cases for affidavits. On criminal cases, as I said, we have set progression orders that go through and they'll tell you whether your client needs to be there or not be there. And then we had these really good, what I thought was really good summary judgment and civil non-domestic rules. And it kind of just spelled out and kind of set things forth. We proposed those to the Supreme Court to utilize. We were told, no, they're going to come up with their own rule on it. It was assigned to Judge Kelch, and then Judge Kelch left the bench, and that's kind of stayed out there. And it causes a lot of confusion. How much time do I get to argue? I'll call up and say, hey, I have a motion for summary judgment. I need an hour. Well, we're going to give you 10 minutes to give your speech. Well, that's independent of the offer of the evidence in those matters. I'm kind of flying a little bit around here. And to step back, I gave instruction at the judicial branch education to 2 of the new judges 2 days ago. And I was in charge of the family law structure on that. And, you know, they come from a different background, not necessarily to know a whole lot of family law. And I gave a glimpse into the judiciary on how well we communicate. I have a work comp judge to my right, but we were texting or emailing, making fun of each other all week. Stephanie and I worked together for years, and I just borrowed Judge Engelman's chambers last month. It's amazing how well we have these relationships with each other, and then we get in a group. For example, the domestic bar wanted us to uniform temporary allowance hearings. And it was my first eye-opening to see judges yell at each other. And what it was is, my system's the best, yours is terrible. And why would I ever go to yours? Because mine's the best. I mean, literally yelling of people that are friends and colleagues and everything else. And it emanates from the practitioners wanting a uniform system or consistency going through. And what I gathered from that is, 1, my system's the best, everyone else stinks, which I agree. But 2, you have to do what works inside your jurisdiction. For example, in ours, Judge Smith receives affidavit and marks them, and we have a record. That works great for Cass County. In Sarpy County, we could have 5. I could have 5 domestic temporaries in 1 week. I don't physically have the space to take those affidavits in there. Along those lines is, I told those judges, I go, do what system works for you, but listen to the practitioners in your courtroom. If you don't listen to them, you get a little bit big-headed, and you get back to that, well, my system's the best, and no one's going to tell me what to do because it works for me. But it's amazing I think all the judges, and I'll speak for all the judges in my jurisdiction, when we're doing those informal pretrials or back in chambers, we're actually soliciting what will make this better for you. If we can get cases done in a quicker fashion that you're happy with, that's kind of the goal. Everyone's there, including the litigants, to keep the money down on it. And that's individuals, and I think I'll speak for most judges, we're receptive to hear that. If it's a problem and you're knocking your head against a courtroom each time, not talking specific to the case, but if you just grab the judge after the hearing and say, hey, have you considered this? We're not going to be dismissive of that because it might be a good idea. Let me tackle this one. We oftentimes get a case that comes in with an argument from counsel and copies of orders from other trial courts. And it's not that it's offensive to us, but I wouldn't want my case that I did a written decision getting sent to Lancaster County and them saying, hey, here's the law of the land on it. We have different facts, different scenarios, and everything else like that. It's similar to, I'll get an attorney that comes in and goes, well, this is the way they do it in my jurisdiction. And I've been on record of saying, well, I'd rather do it correctly than the way they do it in whatever county. I understand the need for that because you want uniformity of practice as it goes through. The fact of the matter is there's a need for consistency, but the trial courts are not the one to set out. That was Judge Castle, his group, that makes what the law is going to be. We can use those as persuasive, but when you get an argument, I know a jurisdiction I can get two opinions from two of the judges and two of the opinions from the other judge, and they're going to be opposite. Well, I'm ultimately going to make the decision because I'm trying to get it right. I'm not trying to get some result that I want or anything else like that. I was waiting for Todd to come in on that.
No.
But that's I kind of just want to leave it that way. I think a lot of practitioners are scared to approach the bench and say, hey, in this type of case, civil non-domestic, we're doing bonds, retirement of bonds. You have us come into court every time. Is it possible that we can appear by video for those? Because there's not a lot going on during this hearing. So you get one time in 10 years, I think I've seen somebody come up and say something. But yeah, I'm like, why wasn't I doing that before? Different things like that on the domestic docket, what works. Now, I will say, after saying don't give us opinions from other jurisdictions, if there's something that works really well in that jurisdiction, let us know about it. I stole District 5's property, and I'm blatant that I stole their form because I said this works really well. It gets the parties talking and identifying from it. Once again, that's in the local rules. I know we're probably going to field some questions from.
Yeah. There's a bunch of questions that have been submitted. Generally on expert witnesses and best and worst use of those. Do you have any comments?
I take that from the perspective as a practitioner. I think expert witnesses are critical. It could push the trier of fact. A lot of times we're the trier of fact. When I'm going to make my opinion, I'm looking at it. I'm not taking gospel truth from one expert over the other, but it gives me a basis to make a decision. For example, I had an expert come in to testify about parental alienation. Out of the state, they came in and testified to it, and it was a very compelling expert, and it probably swayed the case towards the prevailing party. Now, I have the next case coming through. I can spot it a mile away, thanks to this doctor that told me I can't utilize that because that's information and stuff from another time. There's also a cost-benefit analysis to that. I know I had a case that went up on appeal, and the attorney that it was affirmed, and attorney on the other side, we talked about it later. It was dealing with tax implications on retirement. And I made it apples and apples when I compared retirement accounts. I'm a finance major. I know that that's not apples and apples, but I didn't have any evidence to the contrary. So I could treat it as apples to apples. And I said, well, this is what I would expect to see is this maybe a tax accountant come in and get some testimony. And the attorney goes, well, that's going to cost me $10,000. We're only asking for $9,000. I go, that's the power of you being an attorney, and now you have to compromise in those areas. But I think they're extremely effective.
One issue that we talked about last year, and now there's a question on this again, attorney's fees.
Okay.
But the question here is a little bit more specific, and I'd love your general thought on them, but when they're awarded in an amount that's completely different from what the attorney says, and there's no real rhyme or reason to what number is given.
To back up a little bit on that, I was talking to the appellate judges during COVID, and I started noticing on appeals, they're awarding attorney's fees on domestic cases, which I did not see a whole lot of. And I kind of had the notion or practice that I didn't award a lot of attorney's fees in domestic matters. When I asked the appellate courts why was that happening, and I will not point the appellate judge out, but they said, we didn't know you guys were dealing with all of this stuff, or they keep repeating getting a modification filed after modification. So if you look at the cases in 2019, 2020, 21, they start saying prevailing party. For me, I kind of broadcasted about 6 months prior to me starting implementing on modifications an award of attorney's fees, following the lead of the appellate courts. In practice, what we have happen is attorneys offer an affidavit of attorney's fees, and most attorneys are going to agree. You let mine in, I'll let yours in. The only difficulty is that sometimes we get argument about what occurred during the case, and there's a lot of hearsay in with regard to hours dedicated. So the Supreme Court, in its decisions, stated that it's reasonable attorney's fees. That's the problem, is you have judges that say, well, that's reasonable, that's unreasonable. I would have got back into private practice if you guys are getting paid what you're getting paid right now. I mean, I look at it and go, holy smokes, I undercharged, but that was 30 years ago. So I think that is a perfect opportunity on those type of cases where there is an award by statute or by judicial edict to pretrial with the judge and just say, this is what we're thinking about. Are we off base with this argument, or what would you expect if we wanted to substantiate to get to that amount? What would you expect to see? But it's a tough question because it's going to go to what a court sees reasonable.
One more here from the emails is about motions to reconsider.
Okay, perfect one.
And effectiveness of that, if there's something.
So there is no such thing as a motion to reconsider. It's codified as a motion for new trial, motion to alter, amend. That has to be filed 10 days after the judgment and go through. If you look at the cases, if you file a motion to reconsider and that's outside the 10 days, you have waived that. And there's certain things a court can reconsider or alter, amend as opposed to a motion for new trial. And there's different rules for alter and amend as there is for new trial and what you need to bring before the court. It ties into one thing I did want to say is if you're filing a motion to the court, I got beat down with this with my boss in private practice. Put the statutes you're coming under. And that'll, might not be the answer that you want, but let's use the purple books in a fashion that give the court an idea of what I'm doing here. I mean, we're getting inundated with those type of cases, but there's definite time periods and there's some strict case law on what they do. The worst thing I can do is think I have jurisdiction over it, make a decision. My decision stinks, it gets appealed, and then they go up there and you see those opinions by the appellate court. Before we go any further, we must need to know whether we have jurisdiction on this matter or not. And then they don't. And then they don't give you an answer to it. That's, from a trial court perspective, we don't want to do that to you. We want you to be heard on the merits. If we got it wrong, that's fine. Let's get it corrected. If we're right, we high five and back in chambers. But
any other questions for Judge Thompson?
I'm not answering your questions, Andy.
You got him here. It's your chance. Wow. Shocked. We'll move on. Thank you so much.
Right.
Next up, we have Judge Frederick. Am I saying that right? I'm from North Dakota, and I feel like Frederick is the way that I would say it in North Dakota.
It's Frederick. I think they Americanized it when World War II started. So
I mispronounced my own last name anyway.
that's right.
We did our walk through the courts last year, and you had some great information for the new attorneys. So because you stood up and helped us there, you're back for another bite here with some seasoned attorneys. So we'll turn it over to you. Thank you.
Well, thanks for having me, Dave. I appreciate it. So the topics are that Dave asked me to talk about were practice tips, and then some focus on expert testimony at least in our court. And even one of the topics he mentioned was anything new I wanted to get across. And so I'll start with those just real quickly. So just newer rules for those who may have forgotten them or haven't heard of them. Briefs have to be filed in Lincoln. They're now filed now. They're not just a correspondence to the judge. You have to actually file them with the court. Exhibits that you want to offer at a telephonic hearing or any hearing you're not going to physically be present for have to be to the judge 24 hours before the hearing. Some judges will let you send them with the court reporter. Workers' compensation court does not have private. We don't have our own personal court reporters, if you don't know that. So some judges will let you send them with the court reporter. Some won't. I will, just because I think it's fine. But then it comes down to the question, are you paying for the court reporters to print up all your exhibits? And that's between you and your court reporters. The last thing I say, which isn't a rule change for us, but something that the Supreme Court has talked about more recently in some of their cases, is the only evidence they consider on appeal is the evidence that's actually in the Bill of Exceptions. So if you want to make an offer of proof from something that's in the pleadings, which you ask the judge to take judicial notice of, you need to have that marked as an exhibit. And some lawyers get a little irritated with that, and I totally get it, because a lot of times they just say, I want you to take judicial notice of the entire file. And, my file's this thick. And, back in the day when we didn't have this rule from the Supreme Court, it wasn't that big of a deal. We just, sure, I can do that. I'll read something if I have to. But now, for your own benefit, and even these are non-work comp cases, if you want the appellate court to read something as evidence, it needs to be in the Bill of Exceptions, which again is either testimony or exhibits. It's not the transcript. So make sure you bring a copy of that pleading so I don't have to dig it out of my file, which is pronged down, and I have to unstaple it and then make a copy. It's just a pain. Come prepared. If you want the answer to be in the record as part of the evidence, make an exhibit, mark it, offer it. All right. So those are three kind of updates. To remind you all, it's a bench trial, much like Justice Caswell said. As many of you know, some who don't practice in our court, I make the decision or any of my 5 colleagues make the decision, and that's totally different than a jury trial. I would tell you to make an opening statement. There is one defense lawyer who always waives, and that's fine. He's a good lawyer, despite that. But I do think it's important to give an opening statement and to make it concise. Tell me what your case is. Like Justice Castle said, give me a quick theme. Sometimes that's harder on the defense side because you're relying on medical experts, which aren't going to appear in court unless you do have some witnesses who are going to appear on behalf of the defendant. But keep it simple and keep it short and keep it concise. Tell me what the important evidence is that I want to pay attention to. Tell me what the case is going to turn on and what the evidence is going to show. I still get lawyers who like to argue in opening statements. And, the simple test is, the evidence will show. If you can't say that before what you're going to say to me, then you shouldn't be saying it. That's opening statements. The evidence will show. Don't misstate the facts in opening statements, and don't promise to me something that you can't deliver. Even though I am a judge and I've heard several cases, I'm still a person. And so if you say something to me that ends up not being true, or there's no evidence of, or there's just marginal evidence of, that's not effective. And that actually hurts your overall case, because I start to wonder, does this lawyer know his or her case, or are they just not fairly and accurately evaluating their case and the strengths and weaknesses of their case? So it's still important to know your case and to evaluate it and deliver only on the evidence that you plan on offering. Secondly, stipulations, very important, because it shows you've prepared the case. Try and agree to as much as you can with opposing counsel. It is not a sign of weakness at all. It is a sign that you've talked about the case, you know the case, and you're willing to stipulate to things that may even be against your case. Like, we're not asking for that type of relief, Judge. That we can't prevail on that, so we're not asking for that. To me, as a judge, that shows this is a smart lawyer. So the things he or she must be asking for must be something he or she knows that their client is entitled to. So stipulating with the other side narrows the issues, and for you, it helps you focus on what you need to prove at trial. Instead of going, I've got all these issues I need to win, you've narrowed the case down to 2 or 3 issues, and it helps you narrow the type of evidence that you're going to offer at trial and the arguments you need to make. So it shows the judge a lot of things. It shows that you know your case, you know the strengths and weaknesses, and I think it helps you as a lawyer focus in on what's really important. In our court, the rules of evidence do not apply. That's good and bad. But most of our evidence is medical records, the treatment records of the injured worker. You have to know them. Much like Justice Castle said about knowing the record, it's important in our court to know the medical records. Those are critical. They contain a lot of evidence for both sides, and you need to be able to cite to them or know where the certain evidence is contained in those medical records in order to help your client prevail. It's not particularly effective for defense attorneys to ask the injured worker, do you remember when you went to Dr. Jones' office on March 3, 2002, and you said this? Well, there's 2 problems with that. They may not have said that. That's only what the doctor recorded. That's first of all. And that may not be accurate. But secondly, that's 3 years ago. There's not a single person in here who can remember that's what they said at that particular time. A better approach might be taking that medical record, showing it to the injured worker at a deposition and said, Dr. Jones wrote down this as to what happened at that office visit. Would you agree that that's what you said? And they've been given a chance to read it, a chance to think about it. And they go, well, I don't remember exactly, but that sounds about right. And now you've got at least some type of admission that sounds right. And you could even ask a follow-up question. Well, if it sounds right, wouldn't you agree that it probably is right? Yeah, I think that's right. Now you have a locked-in admission, and maybe that statement that you really think is important to your case is an admission that the injured worker has admitted to. And now you don't have to fumble through the medical record at trial. Instead, you could say, and you agree with Dr. Jones when he wrote this in his March 3 office note. And if at trial they say, well, I don't remember. Now I can impeach them with the deposition testimony. Use your medical records in discovery, not necessarily at trial on cross-examination or even on direct examination. It's not particularly effective for the plaintiff's attorney to do that either. Say, and you saw Dr. Jones on March 3, and he has it noted here that your back hurt that day. That just gets boring. You might just say, tell me about the treatment that Dr. Jones provided you. What did he do for you? Or what did she do for you? Was that effective? Did it decrease your pain? Did it help? All those sorts of things. Okay. Quick things on offering depositions at trial. Don't do it. The witnesses, unless that person's not appearing and the parties have agreed. But if the witness is appearing, don't give me his or her deposition testimony. You can offer bits and pieces from it, like 5 pages of the plaintiff's deposition as admissions against interest, that's perfectly fine. But anything else is cumulative, and if someone makes an objection to it, there's not a single judge that won't sustain it. All right, experts. This is the most important type of evidence in our court, expert testimony. You cannot win in our court without it as an injured worker, as a plaintiff. You cannot win without it. Defense can win without an expert witness. It happens, depending upon what the case is. But the thing I would tell you about expert reports is something that Dallas Jones, who's an attorney that does a lot of work on our court, has used in other seminars that we have worked on together, where we present as a panel. Is he says it's the why in the expert report. Make sure your expert explains why he or she holds their opinion. In our court, you don't have to have a doctor come in and testify live. That's the beauty of our court. It reduces your costs, because to get a doctor to testify in court is typically $5,000 to $7,000 anymore, and you can get a written report. I hear they're going up, but for maybe $1,000 to $1,500. But you want to make sure that if you're paying that kind of money, that the doctor's explaining the why. Why does he or she hold an opinion that they do? And I look at that. To me, when I have competing experts, I look at the why. And what do I look at? Is that opinion consistent with the other facts in the case? What did the other medical records show? What did the plaintiff the injured worker testify to? Is that consistent with whatever opinion the expert holds? I look at that. Is that opinion consistent with Nebraska law? And this is where I see a lot of mistakes being made, because I see doctors say, well, it's not, I don't think that the work injury was the primary cause, but it was a cause. Well, in our court, it doesn't have to be the primary cause, and it doesn't even have to be in a civil case. It has to be a proximate cause. And so that type of opinion, if you're bringing that to me from the defense side, that's not helping you at all. In fact, I would offer it as the plaintiff's attorney and say their doctor agrees with ours, and I would ask for penalties at that point. So make sure that if you're going to pay money to your doctor, you might explain to him or her how they need to express their opinion, or even explain what Nebraska law is so that they understand it. Because if they write you a report that supports the other side, you don't have a case, and you have to explain to your client why they wrote that kind of a report. We do see checkbox reports. I'm not against them. I would just say to you, those checkbox reports are something like you ask the doctor a series of questions and then they check the box yes or no. Those are okay. They're not great. But they're helpful when the doctor has written already a narrative report and they maybe just missed something, or they said something not the way you liked it and you want to clean it up. They're perfect for that. And I have a case that I'm looking at right now where I sure wish that would have been done. So use those in those situations. I got, 6 minutes? Is that about right?
Yeah.
Do we have?
Any questions? I have one. So you talk about depositions a lot, but do you think that they're underutilized, overutilized in court from practitioners? Or by the bench? Or
I've seen a few trials where, not many, where they haven't taken the deposition of the injured worker, who's primarily the in most cases, our lone witness at trial. I can't imagine trying a case without having taken the deposition of the injured worker. I mean, how else are you going to evaluate your case and then maybe find other types of evidence to indict their case than talking to them ahead of time? So I think that I don't think that they're underused, because I rarely see that. But as it relates to the deposition testimony, when someone offers to me the entire deposition transcript of the plaintiff, of the injured worker, to me that just means they haven't read it. And they're not ready for trial, because I'm going to offer this in case I forget to ask something at trial. And then at least it's in there. And most times it hurts the defendant, because there are questions. I have to read that thing now, and I do. But there are questions that are asked in that deposition that didn't get asked by the plaintiff's attorney that helps the plaintiff's case. And I've cited to that in my decision. And I just shake my head going, why on earth did you do this? So I think a good lawyer pulls out the pages that help their case, staples the cover of the deposition as page 1 of the exhibit, so I know when the deposition was taken. But that's also an important thing to know. Like, give me the date. Like, does it really? I might impeach some statements in the medical records, depending on what was said and the date. So, I think a good lawyer reads that. You got to read it 2 or 3 times before trial. No other questions. I would just tell everyone, no matter what kind of trial you're coming to or having, show up early. I can't believe the number of people that show up 15 minutes before a trial starts. I would, all my trials were in Lincoln. I would drive to Omaha, and I was there at least a half hour early. And I can't remember how many times I forgot my cross-examination of the plaintiff, and I had to call my office and have them faxed back when I didn't have email on my phone, fax down my questions. I mean, that's an indictment of me to leave my office without it, but at least I got there early enough where I could get a fax to get my questions. So get there early. The court reporters are there wanting to mark your exhibits. So get there early and get everything ready so you start on time.
All right.
All right, thank you for having me.
We'll keep things moving here and get you out of 2 minutes before the 4:15 deadline. Next on the list is Judge Jacqueline DeLuca, Judge of the U.S. District Court Magistrate Judge, and she's in Lincoln, and she's here to talk about federal courts. So let's turn over to Judge DeLuca.
Hi everyone, I'm happy to be here and talk. Can you guys hear me okay? Happy to be here, happy to talk with you guys a little bit about our federal courts here in Nebraska. Before I do so, I am right now the newest magistrate judge on the Nebraska bench. I'm based in Lincoln. We are set to have a new magistrate judge, Ryan Carson, who is currently with the 9th Judicial Circuit in the state court up in Omaha, and he's hopefully going to be starting here within the next few months or so. So we've been busy in Nebraska the past few months since I started in January. While we have been looking for Judge Bezos' replacement here in Omaha as the magistrate judge, Judge Gossett has been helping out with criminal appearances here for those of you that do criminal appearances in Omaha. And Judge Nelson has been taking on a very heavy load of criminal cases in Omaha, as you all may have noticed. The civil cases were split somewhat 50-50 between him and I, and will be reallocated once Judge Carson starts up. So that's kind of new news in the District of Nebraska. Also, as you all probably know, Judge Bezos is the most recent Article 3 appointee. She's up in Lincoln with me now. It's been fantastic to have her up there and have the Lincoln courthouse full again. So it's Judge Gerard, who's senior status now, me, who's the magistrate judge, and Judge Bezos up there. As far as other new news, there are going to be some potential changes that are being floated around with regard to the local rules. 2 things that may be of note to folks in the civil bar, to the extent that you want to weigh in or make any comments with regard to it. The first thing is with regard to block billing for fee affidavits. So to the extent that you do block billing for fee affidavits, you would probably want to take a look at that proposed local rule, which is currently on the District of Nebraska's website. The second potential local rule change has to do with the definition usage in interrogatories. So for those of you not familiar with the local rules of Nebraska with regard to discovery, right now you can use definitions when you are doing requests for production, and you can use definitions when you're doing requests for admissions. The local rules do not allow for definition usage in interrogatories. There is a proposed change to the local rules being floated around in which definition usage can be used in interrogatories. We had a pretty long discussion amongst the local rules committee. We were trying to look for consistency. Admittedly, we are not necessarily bound by doing all definitions. We're just looking for some input back from the bar as to whether we want all definitions or all not definitions with regard to discovery, because right now we're seeing some inconsistencies and some general confusion amongst the bar. So to the extent that that is something that you have a strong opinion of, please weigh in. It would be great to hear from the bar as to those two potential local rules changes. I believe Dave told me one of my marching points was to talk about do's and don'ts in federal court, maybe common mistakes. Being in the magistrate role, obviously one of our primary roles is case progression and discovery disputes on the civil realm. And one of the common mistakes that I consistently see in case progression is something actually very simple. It's folks forgetting that they need court approval for deadline extensions. And I completely understand why we don't do that. We have a very civil bar in Nebraska. We get along really well. And the long and the short of it is we think that if we've got someone on the other side that we know and trust, and we've got stuff in writing indicating that expert designations are not due until a month after the federal progression order says, that we don't need it until a month after that. Well, that's actually not the way the rules work. You need to get that memorialized in an order. And where we see a lot of confusion in this is when folks come back to us and they say, hey, we already agreed to extend this out by 60 days. We were being really civil. Now we want an additional 30 days, and we're not getting along now. Well, the problem is the standard changes. And if you're asking for an extension at the time when you're within the deadline, so say your deadline's August 30th and you come to us on the 29th with some sort of extension request, the standard is different than if you come on August 31st. And if you come on August 31st, after the extension has passed, you actually have to provide good cause for that extension because the extension has passed. So just keep in mind to take a look at the federal rules, the local rules, memorialize changes, even if you guys are in general agreement about it. It will potentially keep you out of hot water and prevent your clients from accidentally missing a deadline. I'll speak for myself, and I think I'm speaking for most of the judges on the Nebraska bench. I think we are very gracious with extensions, so I don't think you need to be scared to come and ask for an extension, especially if it's a new case and you have a good reason for it and you all are getting along. So don't be scared to do it, memorialize it. You'll be in a lot better state. Another, confusion that we see in federal court quite a bit, again, I think it's just cultural between federal and state, is that a lot of folks tend to ask for hearings. Well, we don't do a lot of hearings in federal court. That's why those buildings stay very quiet on the civil side. You can ask for a hearing, and I'm not saying they will never be granted. However, I think if you really do want a hearing, you need to put in that motion why a hearing is going to be beneficial and what you're going to be doing that is outside of that briefing. Because it's going to be unlikely that you're going to be granted a hearing to come in and tell the court what you've already put in the papers. So make those arguments in those hearings so we can understand from your perspective why a hearing is important and would be beneficial for the ruling. A couple other things that we have run across is just with regard to discovery disputes. Now, the local rules require parties to meet and confer in good faith before they file a motion to compel. And after that meet and confer, they are to contact the chambers potentially for an informal discovery conference with the court and with the magistrate judge that is assigned. Now, meet and confer does not mean send an email saying respond to my interrogatories and then someone say no. It means pick up the phone, talk to the people, have a conversation, and try to work it out like adults. I was actually just telling someone a couple of minutes ago, I have a 2 and a 4-year-old, and sometime on these discovery conferences, I feel like I'm talking to them and mediating a dispute amongst the two of them. But remember, you need and you have a duty to confer in good faith. Now, after you confer in good faith, we don't expect everyone to get along. We expect there to be instances in which there are differences in opinion and what should and shouldn't be disclosed. I mean, that's what the job is, to mediate a discovery dispute. So once a good faith meeting has occurred amongst the parties, give your magistrate judge a call or reach out via email and set up an informal discovery dispute. Typically, the way it works in my chambers, and I believe the way it works in Judge Nelson's chambers, is we will ask for short statements. And once we get a chance to review those short statements, we'll go ahead and set a call with the parties. I don't want to speak for Judge Nelson on this, so I'll just tell you how I generally do it. We'll get the short discovery dispute statements in. I will review them. I'll do some research on my own, and then once I get a feel for what's going on, we'll go ahead and set that conference. And we try to do that within a week. We'll get the parties on the phone. If it is something that I think that I can rule on the phone and I think will help the parties continue to progress their case, I will make an oral ruling. And if the parties want me to, I will go ahead and upload their short statements to the docket. The audio will be recorded. It will be on Pacer. So if you disagree with me, you can go ahead and object up to the district court if you want to. And everything that you have been provided will be on Pacer and available to you. If during the discovery dispute conference, a few things happen. One, maybe people start citing a bunch of cases that I haven't read. Or maybe someone says, hey, Judge, I really think that you don't understand what's going on. Briefing might be possible or might be helpful. Or two, I just realized that this is something that is way too complicated to do over the phone and orally. I will put a deadline for a motion to compel, request briefing for that, and then write an order on that issue. But that's kind of the general discovery dispute and some of the misconceptions that I get with regard to discovery disputes. What else, Dave, did you want?
On the point of appealing to Article 3 on discovery dispute issues, and just more, I have two questions, but on the appeal, are there times that you're asked to have it just go straight to the Article 3 judge, that they say this is so contentious, we want to bypass magistrate level and go straight to Article 3, or does it have to
On a discovery dispute?
Yeah.
On a discovery dispute, I think it has to be with the magistrate first, and here's why. All of those have been referred to the magistrate judges by the Article 3 judges, and it's hard for me to see a world, and I'm not saying it would never happen, in which an Article 3 judge would be the first crack at a discovery dispute, particularly when you consider the standard by which the district court judge reviews the appeals on discovery disputes. It's a pretty high standard to overturn. That's something to look at too when you're considering that.
And any big don'ts that you've run across that you want to throw out there?
I've touched on the big basic ones. I think the other things maybe some of my colleagues up here will talk about as well is just remember, you as an attorney for your client know your case better than the judge and the court and everyone else. You know the law better. That applies to your facts of your case. You certainly know the facts better. So don't be afraid to educate the court on what you think it needs to be educated on. Because if you don't tell me, on a very basic level, if you don't tell me that the light's green, I'm not going to know what color the light is. So you need to tell me what's going on, and so that I'm not making assumptions that I shouldn't be making just because I don't work the case. And another basic assumption is you've asked for 4 extensions. This case is now 5 years old. I have no idea why this case is 5 years old. But maybe the long and the short of it is one of your witnesses became incredibly ill. Someone died. There's been a lot of issues going on. And if I don't know that and I'm looking at a very brief motion to extend, it's really, really hard to rule on those motions and put myself in your shoes.
I have a lot less questions for federal court than I do for state court here, but any questions from the audience? Yeah.
Just look at, when you mentioned continuances, does the federal bench recommend a longer continuance? Instead of having to ask for these continuances maybe every 30 days, ask for 90 up front, just to give yourselves the buffer? Or do you prefer a check-in every so often?
So I think, are you talking about more civilly or criminal?
Yeah, civilly. Okay.
So I think first off, and you might know this, at the very beginning of a federal case, there's what's a Rule 26F statement that's submitted to the court, in which the parties work together and set forth deadlines that they believe are realistic progression deadlines. And I'll say it's generally my practice that unless something stands out to me as incredibly odd or pushing the case really, really long, I'm going to defer to the parties as to what those deadlines are. Now, if you're talking to short deadlines in a progression order, I think it's better for the parties to try to be realistic in that, because once again, you guys know your case the best. And then kind of similarly, when we're talking about continuances, if you're asking for a big continuance and it's a realistic reason as to why, and you explain why, I'd rather do the big one than just multiple, like 14-day continuances, 30-day continuances. But just know that if you are starting to get, through that 90, 120 days, the motions are going to be looked at a little bit more to figure out why those types of continuances are even being requested in the first place. Sure.
I'm going to switch to criminal because I think criminal defense. What are you finding from the criminal defense bar is or is not helpful at those detention hearings that we're having? And could you give us some insight into what you think?
Absolutely, and I think that's a great question. Here's the thing, and were you at Panelpalooza last week?
I was for part of it, but I didn't manage my court docket well, so I was forward and going back and forth. So I apologize.
I think that was one of the questions that Petter had asked us to talk with. But the long and the short of it is it's hard, as you know, on those detention issues because you get those pretrial services reports sometimes 5 minutes before your hearing. So it's hard for you to make a case at that point in time. And you're getting it at the same time that I'm getting it, just so you know, to the extent that you didn't. I think what I believe I told Petter, and I'll tell you all as well, is don't be afraid if you need additional time to consider detention and talk with your client to request it. I mean, you're entitled to it pursuant to the rules if you need to make a better case for release of your client. The things that I do find helpful is when we get the pretrial services report, is this person employed? What's their criminal history look like? In the criminal history, if there are state court charges that have been dismissed, why have they been dismissed? If there's failures to appear in there, was there a reason as to why there was that failure to appear that I should know about? So it doesn't look like this guy just continuously doesn't come to court. Those types of things I think are really, really helpful because that not only goes to his criminal history and his risk to the public, but also whether he's going to appear back in court. So those types of questions I feel like are always in my mind when I'm looking at a pre-sentence investigation report and trying to determine detention or release.
Thank you.
Mm-hmm.
So civil depositions. How much is too much when it comes to the objective? What would you like to see the parties say?
I mean, I think the rules require just form and foundation.
Mm-hmm.
So I think you have to be really careful about that. And I don't know if you're talking about necessarily trial depositions. Are you just talking about discovery ones?
Either way, it's mostly is it simply objection form, objection foundation, or is it more?
In my mind, it's form and foundation. And I guess I'll be honest, Michael, that comes more from my practice experience than my experience on the bench. And I haven't really done a deep dive into the practicalities and the legalities of it to the extent that there is some sort of motion pending in front of me. But I will tell you in practice, that's the way that I took it.
Any questions? Chance. So the question I asked before, I'll ask again, and maybe it's unfair because you're fairly new on the bench, but do you think that that attorneys are doing enough depositions, not enough depositions? Do you think that there should be more or less? Do you get any sense on that?
I don't. And I suppose that's a tough question just because it's so case specific. I mean, how complicated is the case? Sometimes it's going to require a lot of depositions. Sometimes you might just need one.
Thank you. All right. Second to last, we have Judge Scheer. And I don't have any lead-in other than I've been working with you on a few committees here of late.
Yes.
And appreciate that. It sounds like there is some news to report. Is it news that we can report today?
About Judge Lowe?
Yes.
Yep, we can report that. Judge Lowe's last day will be October 11th, 2 weeks from today. So we will be, let the games begin.
Yeah.
We'll have an open spot.
Yeah,
sorry. Judge Lowe's, Friday, October 11th will be Judge Lowe's last day, so we will be down one judge. Thanks, Dave.
And that will affect scheduling.
It does affect scheduling, and maybe I'll just start there. If you don't practice in Douglas County Court, I often describe it as organized chaos. There are 12 of us normally if we have a full complement. And the way our schedule works is quite fascinating. Every month there are 3 of us assigned to the civil docket. So the 3 that are assigned in that month will be responsible for civil trials, evictions, restitution of premises, replevins, small claims court, and then they can use that time for their civil trials as well. Additionally, one of those judges will have a criminal jury docket in that month. While you are on the civil rotation, you still are also assigned probably 2 days a month to the probate court, and you still do sentencings every Thursday, criminal sentencings, and then civil motions either the first and third Thursday or the second and fourth Thursday of the month. So how we rotate, for example, my civil months are April, August, and December. When I'm not in my civil rotation, then I'm rotating through the criminal courtrooms and probate and civil motions. So it's a very well-organized distribution of the 12 of us. We get our schedules a year in advance. We are handed our schedules. We know which courtrooms we're going to be in from January 1st through December 31st. With that said, if someone can't be there, if they want to take a vacation, if they're sick, if they have whatever, we have subs available. So sometimes you'll find that the court docket will say that Judge Lowe, for example, is supposed to be in a trial courtroom. He's going to be leaving us in 2 weeks, so someone else will be there. We don't normally try to continue those matters out because if we do, the dockets just get overwhelming. So when one of us is sick, missing, vacation, whatever it might be, we try to fill in for each other. A few things that are going on in county court right now. Almost every courtroom has been updated with technology. We currently have, except for courtroom 20, where restitutions of premises and replevins and collections happen, all of our courtrooms now have cameras for the bench and counsel tables, as well as the witness stand. We have Elmos available to use for evidence, which will project onto the walls, and updated audio throughout the courtrooms, microphones. And every courtroom does now have a hearing enhancement option. So if you are hard of hearing, you can ask and you can wear headphones so the feed will go directly into your ears. If you need it, ask for it. It's just wonderful. And it's the way our courtrooms are designed, especially in the criminal side. We understand there's poles in the middle of the courtroom and it's difficult to hear people who are on the other side of a pole. We can now adjust the volume on the speakers, or you can use the hearing enhancement devices. The only courtroom that hasn't had it updated is courtroom 20, and it's just frankly too busy for us to shut down. We don't have anywhere to put everyone that goes there on a daily basis while we upgrade that courtroom. And quite frankly, I don't know in the long-term plan of the building if that's going to stay there. So I don't know if it's worthwhile to put the money into updating it when it might be gone in a year or two. We have had a huge increase in the use of, because of the technology update and the availability and use of Zoom or WebEx hearings. We're happy to schedule them if necessary. It is incredibly difficult when there is an evidentiary hearing for some of the reasons that were touched on earlier. You have to get us your exhibits. You cannot email them to us. We will not print them off. We need hard copies of them still. I'm on a committee on the Supreme Court that's working on an electronic exhibit that will be statewide. It's in its infancy, but it has been tested. Judge Hanson, I think, just did a trial this last week where everybody submitted their exhibits electronically. They were marked and received electronically. So it will be getting there eventually, but as we are today, just keep in mind if you want to have an evidentiary hearing where you're offering something, you need to make sure we have the exhibits. It's not our judicial assistant's responsibility to print exhibits for the court and exhibits for the opposing party. If you need interpreters, please let us know. We have every day in county court, we have Spanish speakers, we have Spanish interpreters, we have an Arabic interpreter, we have twice a week Karen and Burmese interpreters. We have anything available that you need, but we need to have some advance notice, especially if it's an arraignment or if it's going to be a plea. Just let us know in advance. If we can't get them here in person, we will schedule them to be via Zoom or on the interpreter, the language line. We understand that it's significantly slower if they can't real-time translate, but it's nice to have, when you have your clients there, if we have the interpreter services available and they don't have to come back, it's better for everybody. Let's see, what are some other things? The probate court is an entirely different animal in county court. For those of you who don't practice there, we run every single day. The one thing that I think we have noticed is a failure of practitioners to respond to show cause hearings or to timely comply with deadlines. For example, if you're filing an estate case and an inventory is due, it's due. And not showing up and just ignoring it is frustrating. And we find as a bench that it happens more in that court than anywhere else in the courthouse for us. All you need to do is, if you need an extension, is ask. Inventory is unable to be filed because we're still marshaling assets. Tax returns haven't been figured out. We've suddenly discovered they own property in Kansas. Whatever it is, if you just give us a heads up, it's normally fine, and we're happy to extend those deadlines. But it does get frustrating, especially when we schedule a time and hold a hearing spot and no one shows up and no one lets us know what's going on. We have too many cases in the probate courts to waste time scheduling hearings when no one comes. Let's see, what else is going on in county court? Well, do's and don'ts. I think it's already been touched on earlier today, but for us, it's really important that you're on time. We start at 9, we start at 1:30. We understand that you all have other places, other courts might be operating at the same time. You have somewhere else to be. We're really flexible if you just give us a heads up. Oh, I have a sentencing in Judge Thompson's court in Sarpy County, or I have a pretrial at 8 a.m., 8:30. I know I have a 9 o'clock for you. I might be 15 minutes late. That's great. We're happy to hold the case. But as some of you know, some days we have 70 cases scheduled in a courtroom, and some days we have 7. If you're not there and we don't know where you are, we're just going to pass it by. So, use the email and just let us know if you're going to be late or you can't be there for some reason. And along those lines, when you're there, be prepared. As has been mentioned earlier, the pre-trial conference shouldn't really be the first time that you're talking to each other. I know the city prosecutors are busy, the county attorneys are busy. Other civil practitioners are busy, but talk to each other and be prepared when you're in court. One thing that we have kind of been surprised about, in 2020, the Expedited Civil Act was passed. And we thought that a lot more practitioners would use that Expedited Civil Act for trials. Has anybody used it, just out of curiosity? Does anybody even know what it is? One person. Yeah, it allows an expedited trial time. It starts at 25/27/41 in the statutes. If you are a civil attorney and you have your sole relief that you're seeking is a money judgment, and you're going to file in county court, if you request under the Expedited Act, it really is expedited. And there are modified rules of discovery. You're allowed 10 requests for production, 10 interrogatories, and 10 requests for admission. There's a real hard deadline as far as when discovery must be completed. Treating physicians are designated as experts for purposes of the Expedited Act. There are rules that kind of bypass any sort of foundational objections to reports if you provided the other party the report in discovery. It's well worth your time if you file under that act and use it. We have noticed the cases that generally get filed under that act get settled really quickly because as soon as service is made, the clock starts and the pressure's on. So if that's an area where you practice, I would suggest using that act.
Both sides have to agree to
that? No. It can, when the plaintiff files, they can request. So Along those lines, I think Douglas County's civil court is, I don't know how backed up you are on your civil docket, but not at all? No? Are you sure? Okay. We move, I think we move quicker than district court as far as getting things moving. Don't forget that by statute, even though you might exceed the jurisdictional limit, you can still file in county court. If you prevail, the only thing you have to do is pay the filing fee difference as part of a fee. So that's another, I guess, civil practice point. Anything else? Experts. I'll just touch on experts. We're county court. The rules of evidence don't drop away when you're in county court. The rules of, what's required when you want to make your case don't drop away. So if you file a case and you say that something wasn't completed in a workmanlike manner, even if you're in county court, you need to have somebody come to be your expert to say that. I do feel like sometimes practitioners get a little loose with the rules of evidence or what would be required because it's county court. But the standards are still the same. But I would also say don't overthink what you need in an expert. Every expert doesn't have to be a physician or somewhere along those lines. County court controversies come up over, concrete, paint, whatever it might be. Just find someone else who has a concrete company and have them tell us that it wasn't mixed properly or whatever it is. But don't forget that the rules are the same in county court as they are in district court. Any questions?
Judge.
Yes.
So when we are double booked and I'm one court over here and I'm going to be running late for a civil hearing on this side, would it be best to call your office number or the clerk's office that I'm going to be going to?
Either one, or you can just shoot an email to me or to the as of just 2 months ago, each county court judge now does have an assigned judicial assistant. Or you can call the main number at 5428-5429, the 444 number, and they'll shoot an email to our assistant. There's one practitioner who regularly on Thursdays will send an email that says, I have 6 cases filed at 9. 2 in Judge Marcuso, 1 in Judge Lowhouse, 1 in Judge Harmon, 1 in Judge Scheer. Here's the order that I'm going to try to go to. And just so we know, that's fine. Yeah. Yeah.
Protection order cases.
Yes.
What evidence do you want to see from us and what evidence would you not like to see?
Well, you can present any evidence that you want. I will say that, when we review a domestic abuse protection order, we either have to grant it ex parte or set it for a show cause. So if it's set for a show cause, that means whoever reviewed it did not believe there was enough in the protection order to grant it ex parte. So as a practitioner, if you're coming in front of any of us with a domestic abuse protection order that's set for a show cause, know that if the petitioner is your client, they didn't get over the hump. And so whatever you need to do to convince to get over the hump. Obviously, we're supposed to be limited to the content of the protection order. I don't want to hear about things that happened 12 years ago if they're not in the protection order. But, they're an interesting beast. Usually people are pro se, and Todd, you can talk about this a little bit. But if you're representing your client, I just, look at the statutory requirements and then try to focus your evidence so that it complies with those. Oftentimes, we have protection orders that are essentially substitutes for a custody case, a dissolution, an eviction. That's not what they should be used for. So I guess I'll leave it at that.
Let me pick up a little bit because, Michael, on the protection order, the committee, the judicial committee on it, It's myself and Judge Hansen. And we've tried to implement uniformity, and I'm going to go back a little bit to my system's the best system, everybody else stinks. And I know what that places practitioners in. What do I need? Am I calling witnesses? I've got a minor child. Do I have to have it in chambers? Do I have to do all of that? It is, I don't think it's improper to almost pre-trial the case with the court, saying, before, the day or two before, just to say, what are you going to expect, or how are you going to run the hearing? The script that Judge Hansen and I came up, we borrowed it from Judge Flowers on how to do it, and we try to get uniformity, and we teach all the new judges, this is kind of the way you have it. The problem is every jurisdiction is different, and I think that's why it's important to find out, rule of thumb on it is the hearing should last no more than 15 minutes. That's kind of surprising, but that's the mindset of when we put the program together that the Supreme Court looked at and said there. There was also a great idea, have referees do the protection order hearings. That way you have available for them, you have time, because trying to fit one in on a county court schedule is nearly impossible. On the district court schedule, we're probably have a little bit more time to do them. But it's our nightmare because we think it's different in every jurisdiction that you go to. I think just maybe touching base, even if you don't have an open case with a court in that jurisdiction, just to ask the judge, hey, how do you run these? Or what would you expect during my presentation evidence, whether I'm the respondent or the petitioner? I just think that's, like, once again, we all do them differently.
Yeah. Really quickly, I think I'm almost out of time. As far as protection orders in Douglas County, just so you all know, between district court and county court, there's 30 judges. And how we are currently operating is we are basically on a wheel. And so I get every 30th protection order that comes in. And so that's how they're assigned. It's just randomly like that. If you have a client who makes application for a protection order and you have a open dissolution docket, you can ask to be transferred to the judge who has the dissolution or the child custody, just to keep it. It just makes sense to all of us. It's just that the clerks don't always know that. So if you are in that situation and you want to ask to transfer, it's a real simple request. Or the other way, if you have a client who already had a protection order heard by myself or another judge, and then somebody else files or refiles, you can ask that it be assigned back to that person. So it's just a random assignment, but you can always ask to move it if there's a legitimate reason. And then one other thing that I wanted to touch on that's going to be happening in county court, and Dave and I are on this committee, there's been a grant that was approved to start a self-represented litigant pilot project, essentially, in Douglas County. We are working right now to try to fashion how we will make forms more available, more accessible to self-represented litigants. The former display case, now office that's downstairs across from the law library, will probably be utilized for that. We will be definitely looking for volunteers to help people to, quote unquote, navigate court, not to give legal advice, but just to direct them to where they need to be. So that's something that should be kicking off probably in January, I would guess, if not before that, hopefully. And we'll see where that goes.
I'm going to come back to this. It's been a few years. Limited scope representation. Do you see that in your courts at all? And if so, is it a good area for maybe practitioners to get into?
I really like limited scope representation. When I was in private practice, I utilized it quite a bit in dissolutions for people just to kind of help them at one point, and then they can get out, or you can get out and do it themselves. The most that I see it now is in the when restitution of premises. The Tenant Assistance Project has been here in Douglas County since COVID, and they are every day using volunteer lawyers, and they're pretty much the only limited scope that I'm seeing right now. I would encourage people to utilize limited scope in your practice if you can. Sometimes people come, they really just need a little help, maybe drafting the original documents or whatever. You can make a limited appearance. Don't forget to file your request to be released from your limited scope if you do that.
Any other questions? All right. Last but not least, you can't say what they all said here at the end. He's got 20 minutes.
Ditto.
Yeah, he did that a couple of years ago after Judge Stratman. We're not going to allow that today. No, Judge Engelman.
Along like what Judge Scheer just said, our jury trials, I mean, if you want a jury trial week, the first available one I'd be having is like May or June of next year. That's how far it is out. And on every jury panel I have 3 or 4 juries set. One is a primary and a whole bunch is a backup. I have one jury week in December, and I had 3 jury trials set that week, and they all settled yesterday. So now I have nothing that week. So, but my bailiff, the point of this is my bailiff will try and contact people to get hearings put in there if you want hearings. So don't be afraid when judges tell you I don't know if other judges put regular cases on their jury weeks. I do, because if I don't have a jury trial going, then I want something to do, and my bailiff hates me having any free time to do anything I want to do, so she crams as much as she can into every free minute of my life. But on other stuff, going what Judge Thompson said, local rules, domestic people need to keep looking at local rule 43E14. Before you file complaints to modify and contempts, you have to attempt mediation. You have to put in your application or your complaint to modify when you attempted mediation, who you attempted it with, and what the result was. The purpose of putting that in is because we were getting so many just silly contempts that can be handled in 5 minutes with a mediator. It's this person put the kid in the school and changed the school. Any mediator is going to tell you, you can't do that. It's right in the parenting plan. You can't do that. Go change it. Go fix it. But people still don't do it. So keep looking at that local rule, because if I get a complaint to modify or an application for contempt on a parenting plan that doesn't have that in there, I just dismiss it. It's not in compliance with the local rule. And then the attorneys get mad and they're like, well, you just missed my case. It's like, yeah, go read the local rule that says you have to do this. And then the question comes up, well, what happens if this person's withholding my child? Well, there's a specific statute for enforcement of parenting time and visitation. It's 42-364-15. File it under that. You're not filing contempt. You're filing a motion to enforce my parenting time or visitation. I can award attorney fees under it. All of the same things go along with it. So you can, not in effect to get around the local rule, but the purpose of that statute is if someone's withholding your child, you have a means to file to get into court and get that parenting time started again. Another thing, I love picking on domestic people because I was a domestic attorney, but temporary affidavits too. Can you please, for the love of Pete's sake, put your client's work schedules in their affidavits when you come in and ask, my client wants custody. Well, what's your client's work schedule? I don't know. I think he's here. I'll go ask him. Oh, he works nights. What are you going to do with the kid? Oh, I guess we haven't thought about that. Okay. But beyond that, we're trying to set parenting time schedules of pickups, drop-offs, all of those things. It's helpful for us to know beforehand if your clients get off at 3 o'clock or 4 o'clock or 5 o'clock or they work nights. We need to know those things so we're not wasting 15, 20 minutes in chambers in a temporary hearing trying to figure out when we can do pickup and drop-offs. So those are simple things that you can put in your affidavits that speed up the process a lot. And like George said, I stole their pretrial order. So in all my domestic cases now, and I got at least half of the bench on board. Trying to get my bench to do anything is like herding cats. It's impossible, but I've got at least half of them on board to start doing these pretrial orders because I've seen a dramatic reduction in my lost trial times. Because when I first got on the bench, we were setting domestic trials, and I'd have 3 or 4 domestic trials set Monday, Tuesday, Wednesday, and Friday. The Friday before, every one of them would fall out and settle. And so then I'm sitting there with and people are wondering why they can't get court hearings and why they can't get in to see the judge. This was why, is because our calendars were getting filled up with all of these cases that really should be settling and really will settle. But I think attorneys got into the practice of, but if I set it for trial, then it's going to make the parties talk. So, all right, I won't give you a trial date until after the pretrial date, which is usually 4 or 6 months out from when the person gets served. You got to attempt mediation and you got to do settlement facilitation to try to settle the property. Then you come in at the pretrial and then you can tell me we have 2 issues left. Great. I can give you 2 hours next week or next month instead of first time I have a free day for a trial is April of next year. It's not fair to your clients to have to sit around wanting to be divorced for 6 months to get in for a trial date. And then they blame us, and it's not our fault. It's how it works. So I have seen a dramatic reduction in setting domestic cases for trial and actually having trials because people have to actually get together and talk and figure out what they're doing. And then they come in for the pretrial and they're like, we think we're going to settle all the property. We got a parenting plan already done. Great. I'll set a status in 30 days. We'll come back for a 15-minute hearing. If you got everything settled, we're done. And it is dramatically reduced, clogging up at least my docket. So that's one good thing. On an update, Judge Wheelock and I are on a buildings committee. Trying to get anything built in this building is virtually impossible. And just because this is a stone structure. But at present, we've been approved and are in the planning, hope to get building very soon, 2 new courtrooms on the 6th floor for Judge Benson and Judge Vaughn. So they'll have full jury courtrooms, jury boxes, jury rooms, everything. The long-term plan is to move the clerk's office from the 3rd floor down to the 1st floor where the county attorney's office used to be. And then we want to make a huge, like a federal courtroom on the 3rd floor with 4 or 5 counsel tables so we can do multiple defendant criminal jury trials in there, larger civil trials. And the goal is to maybe keep that courtroom open for whoever needs it. So we don't have to keep bouncing around like I spent my entire June in Judge Polk's courtroom because I have a tiny courtroom and I had back-to-back co-defendant murder trials. One went 2.5 weeks and one went a week and a half before they then pled. But even then it was impossible to get everybody in those courtrooms. And he's got one of the bigger courtrooms. The other part is where the old county attorney's space is on the 1st floor. We're working on getting a jury assembly room so that when we bring juries in, we can have 4 counsel tables, we can have a bench, we can have the TVs, we can have everything so the judge can go down there. Like my 2 jury trials, I had 100 and some jurors in the pool because we had 2 defendants. So it took days to pick juries and we did it in here. And if you've ever done anything in here, it was like 9,000 degrees in here. I'm sitting up there in a corner. We got some attorneys here. I've got 2 defendants that are sitting here. I've got 800 deputies in here and 150 people sitting out here. It's not good. So we're trying to get that fixed. Some other stuff on courtrooms. Like we were talking, our courtrooms are very mic'd up right now. I have microphones everywhere in my courtroom. I can hear everything that is said in my courtroom. I've been in trials and I've heard people talking in the back row on my speaker, talking to each other when it's quiet. Now I have even more speakers because now I have microphones hanging over the gallery, over the jury box, everywhere. So when you're in courtrooms, just be careful that those mics are always on. My bailiff's got a speaker right next to her desk. She knows if people are in there talking. Keep mindful of what you're saying. There's also cameras on. I always have my cameras on so I can sit in my office and I can see what's going on in the courtroom because I want to know if people are walking in and walking around and what's going on. And I can't tell you how many times I've gotten on an elevator or walked out in the hallway and you hear attorneys talking to other attorneys or their clients about this idiot judge or that idiot judge, and this judge is going to do that. Don't worry about this. And you're just standing there like, hi. And I mean, it's happened. I've been standing on an elevator in the back of the elevator and people were talking not so nicely about one of my fellow judges, and then when they got off the elevator, they realized I was standing in the back, and you see the color just drain from them. So be mindful when you're in the courtroom, what you're saying, it gets around. Some do's and don'ts. That was a do and don't. Don't use your cell phones in the courtroom, even as attorneys. Ask the judges if you can check your phone to get your calendar, all of those things. My bailiff watches the cameras too. When I'm in trial, she's sent me emails before, hey, the attorney is sitting there playing on their phone. I'm watching the witness, and I look over and they're just reclined back, sitting there playing on their phone in the middle of a trial. There's at least 2 or 3 signs when you walk into every courtroom that say you're not allowed to use your cell phones, but people still do it. So don't. A do is we have trial orders that say get your exhibits in 10 days before trial. Get your exhibits in 10 days before trial. Nothing irritates my staff more than 4 o'clock the day before a trial, somebody sends 50 exhibits in and wants her to mark them. She's like, you should have had these to me 9 days ago. I do everything electronic. I don't want paper anything. So our trial orders are you have to get electronic copies of your exhibits. My bailiff goes through, puts electronic exhibit stickers on them, gets it all set up and sends it back to the council so that when you guys show up at trial, all of your exhibits are there. They're all numbered. They're all ready to go. And then you get the person who shows up the day before and wants to mark 40 exhibits, or shows up the day of trial with 40 exhibits. And then you waste an hour of trial time going through and marking exhibits and getting them ready. The other part about exhibits, especially domestic cases, a lot of times you guys don't object to a lot of any of the exhibits that come in. Go through them with the other attorney beforehand. So when we come out, you can go, Judge, we stipulate to 1 through 70. Great. We don't have to waste hours of what is this? How does it prepare? Does it fairly and accurately depict? We can just get to the point of what we need to get to. So when I start domestic trials, I typically go out and tell them, go through your exhibits for 5 minutes, find out which ones you can stipulate to so we can put it on the record right away, and it's done. Then we can speed up the trial process. But that goes into with actually reaching out and talking to your fellow attorneys in a cordial manner and being polite. I have a top positive differentiators for attorneys to focus on. That's a good question. The thing I would say is that think about your case from the other person's side. So then you know what to expect when you go to trial. Don't just myopically focus on your side and your position and everything else. Look at it from both sides and understand where they're going to be coming from. And along those lines, go through your exhibits, know your exhibits. I can't speak for all judges, but nothing is more when you see an attorney fumbling with exhibits and they've got papers all over their desk and they're looking for an exhibit and they're wasting 5 minutes of time and trying to find an exhibit, and then they bumble it and they show them an email and say, what does that email say? And you're like, you missed about 14 steps before you get to what does that email say. So know your exhibits, come prepared, know how to handle them, know how to work your way. Something to not do, be kind to our bailiffs. They run our schedules. So if you're not kind to our bailiffs, that's not going to go unnoticed. Trying to think of anything else.
Anything on experts?
Experts, civil trials experts, it's not a big problem because those attorneys have had that case for 9 months to 2 years to 2.5 years. They bring in their experts. They hammer home their points. Those experts have also written reports. It's more the domestic cases. Sorry. When you guys bring in experts, first off, know what they're going to say. Because I've had one where a therapist came in and this attorney, this was their expert, and every question he asked of her, she's like, no, I don't agree with that. And it's like, why did you have her? And trying to get stuff out of her that she was not going to let out. he was trying to get into areas that she wasn't called for, and she was shutting him down. And it was just kind of comical because you're just like, this is not going well for you, and this is your witness. So know what your experts are going to say. Prep them beforehand. It's not illegal to prep them to go over what they're going to testify to so you can get through it smoothly and so you know what they're going to say. Because nothing's worse than you bring in a therapist and start asking them stuff, and then they're like, no, I don't think that's right. I don't see that. Do you see this child affect differently with this parent? No. Well, I probably should ask that beforehand. So that's the only thing, is just prepare your experts, know what they're going to say.
Any questions?
No.
Yeah, Megan. Megan.
For criminal court appointment cases, there's something going on where sometimes we submit our case in the case, and then we see large amounts have been deducted, and we're not sure why. So, in terms of submitting our attorney affidavits at the end of an appointed case, is there a best practice or things that we want specified so that we're not running into a situation where our time's being used? And Judge Shear, normally I'm on this is happening in crime as well.
I was going to say, I've never reduced an attorney's fee request in a criminal case. I know some attorneys or some judges have, and there's good reasons, because sometimes you see attorney fee affidavits that are like, I did 6 hours of legal research in one day. And you're like, really? This case took a total of like 2 months. And what were you doing 6 hours of legal research on? That's one of the rarer ones, but I try to get attorney fee affidavits signed, filed as soon as possible, get them out, get people paid. And then larger, like my 2 murder trials in June, I had those defense attorneys submitting along the way so that they weren't, because those cases went on for 2.5 years in one of them. So I was having them submit them about every 4 months so that they weren't having to do all of this work and not being paid for it till the end.
Follow-up, did you issue an order that allowed them to submit for interim fees, or did they complete that request?
They just came in.
And county court recently, so within the last year, we've changed a little bit the attorney fees affidavits, how they're handled. It used to be reviewed by the presiding judge after we signed off on them, regardless. The presiding judge just had too much to do. And so now each judge is responsible for reviewing their own. We know we don't pay you enough to do what you do for us, but we have to set the rate based upon the volume that we have and the budget that we have. Some judges really will be a stickler in reviewing. I mean, they might go look at the journal entry in order and see what time it was printed in. So you said it was an hour, but you were out of there at 9:32. So that really wasn't an hour of time. I don't think the majority of us operate that way. But, we do have the latitude. And same sort of thing. If someone says they did, it's a simple misdemeanor and they spent 17 hours on it, you're not going to get paid for 17 hours. It's just not going to happen. I would say if you've had that experience and it's okay, you can go talk to them and ask them why they did it. They're not going to hold it against you. They might have made a assumption or misunderstanding. I don't think it's out of the realm, but generally you shouldn't be billing the county court for travel time. And I think that's one thing that the judges look at and might take off. But we appreciate it. On that note, if you're willing to take appointments, all you have to do is send a letter to our county court administrator or the district court if you want to take felony appointments. And if you have any interest, I would encourage you to get certified as a guardian ad litem for the probate area. We desperately need people who are willing to serve for us. They're appointed generally in more contentious cases, I would say. But we do need the help of guardian ad litems. They just serve an amazing role in the county court, and there's, I think, only like 10 attorneys right now on that list that have gone through the training.
If you go to the Supreme Court website, they have dozens and dozens. And when I went through the names, I'm like, they're no longer practicing, they're no longer doing it. And I talked with one because I was surprised. And they said, yeah, when I was in another county, I was in the public defender's office and they wanted us to get it. So I don't touch those cases at all. But if we were to try to expand our list and district court, I don't know if it's the same way. Internally, we have a lot of like a criminal that's going to come through, at least in Sarpy, on the wheel out of the county court. But when it comes to guardian items, that's kind of our list, and my list has shrunk so much that I was soliciting people. I don't know, Todd, if that's the same in district court in Douglas.
I'm not seeing a lot of guardian items in cases. I don't know if there just aren't any or people aren't using them. I don't know. But the same with the travel time. That was something that came up last year when I was the presiding. We started getting a lot of criminal fee applications coming in with travel time. And one of the judges finally said, we're not paying people to travel to the courthouse. We'll pay you travel time if you're going to the penitentiary to meet with your client or something like that, because then you're going out. And that never occurred to me because from private practice, I was billing from the second I left my office door till I got back to my office door because I billed for travel time. So
on that note of using guardian ad litems in domestic cases in the district court level, has there been any discussion about creating some kind of uniformity about how those services are accepted? At least I would say I'm finding it is so hit and miss with judges. Some judges won't even entertain the idea of using a guardian ad litem in a contentious custody matter. Others seem to be a lot more open to it, and so I think it makes it more difficult to advise a client. Is this something worth pursuing? Because you want to advocate for your client, and especially when it's going to be beneficial to your case. But then we're left in the position where we've now wasted our client's money drafting a motion, setting it for hearing, talking with the other counsel about it, when a judge is not even going to entertain the idea.
You missed the part where I said doing anything in my group is like herding cats.
Yeah. Well, and I think there's a confusion because if you go back, there's a case, I think it's DeVoe versus DeVoe, defines the guardian ad litem. Now, the traditional guardian ad litem role in the juvenile court is different than we're going to have in district court. Really, a guardian ad litem in the district court is an investigator for the court when they don't believe that the information, they're not receiving the proper information to make an informed decision. That's difficult because when you have juvenile court, they're weighing in on best interests of the child and everything else like that. But strictly from a district court, the guardian ad litem should be reserved for those matters the court does not believe it's getting the correct information. And the rules that involve in that are, at least at the district court level, the guardian ad litem can have ex parte communication with the court. Now, that cannot occur in juvenile court, but the case law is pretty clear that in district court that can occur, and the only way that can occur is this is an agent of the court, not an agent of the parties or anything else. I have also seen where it might be important to appoint an attorney, in fact, for the minor child, because you have competing interests. But therein lies the difficulty is what the guardian ad litem's actually supposed to be doing in a district court as opposed to juvenile court. You can't have that type of guardian ad litem for that reason appointed in district court, but that's going to prevent the court from having ex parte communication with the guardian ad litem.
And I understand your frustration because I know from private practice and now being on the bench, like temporary hearings, I know there are judges in my building that you get one temporary hearing. That's it. And I know there's some that if you set it for a temporary hearing and then you don't have it, you've used your temporary hearing. You don't get one. I'll have as many temporary hearings as you guys want because I understand that as divorces progress, things change and people's schedules change, their work schedules change, things happen during divorces. And so I'm open to as many temporary hearings because if you can handle those now and not wait 6 or 8 months for it to be set for trial, if you handle those things as it goes, 9 times out of 10, those cases then settle and those people work it out. So I don't know what to tell you with that. It's just, I can only control what I can do.
Yeah. Okay.
We have time.
Yeah, one more.
I'm interested in Judge Engelman's response, but I think
No,
this is
no more questions.
Well, I think anyone on the panel could answer. We know that ex parte communication with the court is generally prohibited. Is there an appropriate way for an attorney to get feedback or insight from a judge about a decision made or the attorney's performance, or any way to process when there is this general bar around
I've had attorneys come in after jury trials or after very contentious. He's not here, he now left. But I had one case that, the trial was like a week and a half long in a domestic case, and then there was a week-long contempt, and then there was another week-long contempt. That attorney came in and asked, you're not asking about the case, he was just coming in and asking, hey, how did I do? How was my performance? How did I handle exhibits? How did I do all of these things? Was it okay? And do you have any feedback on? And no, he did a great job. So I don't think that's ex parte to come and ask a judge, how did I do? Is there anything I can do to improve? Because there was one civil trial attorney, he was very good, but he was just something about every time he would start and I'm like, you realize that when my court reporter types that up, so just be mindful of your because when that transcript comes out, you might kind of look silly. That every single question you ask starts with let me get to it's like, just be mindful of that and just get to the question. But you're not talking about the case. Are you talking about, like, if I rule poorly against you, you want to know why?
Honestly, sometimes I guess short of an appeal, is there any respectful, effective way to engage the court if you really disagree or think the judge got the facts wrong, or you just don't have any insight? How did we get here after that?
That would be the motion to alter.
Yeah.
Unfortunately, but the other thing is we're prohibited from providing clarification of our orders by Supreme Court rule. There's one thing that you had said that I can't emphasize enough. If you send an email to the judge and carbon copy the other side, that's ex parte communication. That's subject to discipline. Usually the bailiffs or court staff will have that off. We don't ever read those. You can for scheduling purposes, but that's, I think, where the trepidation of approaching a judge after a case. I will always talk to attorneys after, if I know that appellate time is run and it's really nothing that's going to come up again. I generally break it down a little bit and say, because I'm going to reciprocate it. What did I do that annoyed the hell out of you during the trial? And they say, well, you weren't paying attention. I'm like, well, we're going to disagree on that one. I think that's the concern we have. If it's subject to an appeal, or if it's asking us to interpret what we said or ordered, until that appeal time is run there, I can't emphasize enough, we're trying to get it right. We're not trying to get an outcome. And that's really, I think, maybe some misconception of the minority of attorneys. They think that we know all these facts. As you're saying, we don't know what's going on. This is when we're getting into trial, and we're trying to get it right. We've got too many other cases to worry about to manipulate a case into where, he didn't like the attorney, so that's why you ruled that way or she ruled that way. And really, it's like, no, I just don't want to get reversed on. You reverse me on the law all day long because I'm not that smart, but don't reverse us on the facts or what got presented to us.
Ditto.
There it is, the ditto.
Ditto.
Well.